Superior Court of the State of California, County of Alameda, Department 1 is now in session. The Honorable Judge Carville presiding. You may be seated. Your Honor, at this time, may I address the court as to the rules to maintain order in this courtroom?
Please do.
At this time, please silence all electronics, including cellular devices. There's to be no eating, drinking with the exception of water, or talking for the duration of this trial. Failure to comply with these rules will result in immediate removal from this courtroom.
All right, I believe it's customary to have each team introduce itself. I believe we start with prosecution. Is that true?
Yes, Your Honor. May I proceed? Good evening, Your Honor. My name is Rama Narayanan, N-A-R-A-Y-A-N-A-N, and tonight I represent the people of the state of California. I will be delivering the pretrial argument for prosecution. At this time, may our trial attorneys please rise and introduce themselves?
Please.
Good evening, Your Honor. My name is Brenna Lonner, L-O-N-N-E-R, and tonight I represent the people of the state of California. Tonight I will be conducting the opening statements, as well as the direct examination of Sawyer Smith and the cross-examinations of Reagan Klein and Sam Kolostian.
Good evening, Your Honor. My name is Suhas Nagar, N-A-G-A-R, and I represent the people of the state of California. Tonight I will be conducting the direct examinations of Officer Keegan Lopez and Dr. Dakota Chung, as well as the cross-examination of Dr. Blake Williams.
Good evening, Your Honor. My name is Ayush Singh, S-I-N-G-H, and I represent the people of the state of California. Tonight, I'll be conducting the direct examination of Cameron Holmes, as well as the cross-examination of Marlo Patterson. I will also be delivering the closing argument. At this time, may our witnesses please rise and introduce themselves?
Please.
Good evening, Your Honor. My name is Himani Pangal, P-A-N-G-A-L, and tonight I will be portraying Cameron Holmes.
Good evening, Your Honor. My name is Sujana Sridhar, S-R-I-D-H-A-R, and tonight I will be portraying Sawyer Smith.
Good evening, Your Honor. My name is Isha Shah, S-H-A-H, and tonight I will be portraying Officer Keegan Lopez. Good evening, Your Honor. My name is Nicole Park, P-A-R-K, and tonight I will be portraying Dr. Dakota Chung. At this time, may our clerk please rise and introduce herself?
Good evening, Your Honor. My name is Anjali Ramesh, R-A-M-E-S-H, and tonight I will be serving as your courtroom clerk. I will be timing all direct and cross-examinations, opening and closing statements, along with the pretrial argument. And I will be providing visual cues for 2 minutes, 1 minute, 30 seconds, and stop, for which I will issue both a visual and verbal warning. At this time, may our teacher coaches please rise and introduce themselves?
Please.
Good evening, Your Honor. Mari Wolgamuth, Teacher Advisor.
Good evening, Your Honor. Lori Mullins, Attorney Coach.
Good evening, Your Honor. Jadel Cuevas, Attorney Coach. Thank you.
Yes, Your Honor. Good evening, Your Honor, and opposing counsel. My name is Jasmine Campbell-Nathan, for Reagan Klein in pretrial motion. At this time, may our trial attorneys please state their appearances for the record?
Good evening, Your Honor, and opposing counsel. My name is Megan Toe, for Reagan Klein.
Good evening, Your Honor, and opposing counsel. My name is Aidan Arnold Galati, for Reagan Klein.
Good evening, Your Honor, and opposing counsel. My name is Arun Balaji, for Reagan Klein.
Now may our witnesses please introduce themselves.
Good evening, Your Honor. My name is Amber Loza, but tonight I am Marlo Patterson.
Good evening, Your Honor. My name is Mehul Jain, but tonight I am Sam Kolostian.
Your Honor, for tonight's proceedings, I will also be Dr. Blake Williams.
Good evening, Your Honor. My name is Declan Dempsey, but tonight I am Reagan Klein.
At this time, may the courtroom bailiff and unofficial timekeeper please introduce themselves.
Good evening, Your Honor. My name is Brooke Muniz, and tonight I'll be serving as your courtroom bailiff.
Good evening, Your Honor. My name is Nathan Maffei, and tonight I will be serving as your unofficial timekeeper. It will be my duty to work in collaboration with the clerk to ensure that time is kept to the utmost accuracy.
Finally, may our coaches please introduce themselves.
Good evening, Your Honor. Peter Baruso, attorney coach.
Good evening, Your Honor. Phil Wilder, teacher coach.
With that, the defense is ready to proceed.
So this is the case of People versus Klein. I understand there's a motion.
Yes, Your Honor.
Proceed.
The Constitution safeguards an individual's right to free speech. Yet the prosecution wants to criminally punish my client for the words that he spoke online. But because Mr. Klein's statement is not a true threat, it is constitutionally protected free speech, and therefore the defense moves to dismiss count 2. In assessing whether or not Mr. Klein's statement is a true threat, the courts look to 2 factors dispelled through the case law. 1, that the statement be a clear expression of an intent to commit an act of unlawful violence. And 2, that that statement would put a reasonable person in fear for his or her safety. Because neither of these factors exist in our case, Mr. Klein's statement is constitutionally protected free speech, a right guaranteed to the American public by the First Amendment. And it's a right that we as a society do not want to stifle. I'd like to begin by addressing that first problem. Mr. Klein's statement was not a clear expression of an intent to commit an act of unlawful violence.
He said he was going to kill the other person, didn't he?
No, Your Honor. Mr. Klein said that he's coming for him, that he's going to get Miss Smith. Those words are so unclear and equivocal that no reasonable person could believe that their vagueness even implied a threat to Miss Smith's physical safety. Those words are nothing like the very clear, specific words in cases like People v. Allen or DCBRR, where there's a very clear, true threat that is not and should not be protected by the First Amendment. Your Honor, I'm coming for you is nothing like, I'm going to kill you. I'm going to kill your daughter. Those were the words in the case of People v. Allen. And I'm going to get you is nothing like, if I ever see you, I'm going to pound your head in with an ice pick. Those were the words in the case of DCBRR.
Is the issue whether certain magic words are used, or is it a more subtle inquiry?
We have to look at the entirety of the message, Your Honor. However, even when we do so, we see that the words themselves are too vague to convey a true threat. Moreover, the cases like People v. Martinez specifically state that vague statements like, I'm coming for you, are insufficient in conveying a true threat. And because Mr. Klein's statement was so vague, the second factor does not exist in our case. Mr. Klein's statement would not have put a reasonable person in a state of sustained fear. All we know from the statement is that Mr. Klein was upset. Upset not even at the fact that his best friend dropped him as a friend, but because his friend then gloated about getting him fired after posting a mean message online. Miss Smith posted, "The feeling when you win, hashtag too bad, so sad." And it was only then when Mr. Klein responded with this mean statement. It wasn't some deliberated true threat that the prosecution would have you to believe. Now, the courts have ruled in the case of In re George T. that there are circumstances which could raise a vague statement like Mr. Klein's to a true threat. But because those circumstances don't exist in our case, Mr. Klein's statement still is not a true threat and would not have put a reasonable person in a state of sustained fear. And I'd like to address 2 of those circumstances that are in contention today. One being a history of animosity, and the second being immediate conduct suggesting an immediate prospect of an execution of a threat to kill or cause great bodily injury. First, starting with a history of animosity. Now, the courts never clearly define what exactly constitutes a history of animosity, but when we look to the case law, we see that a history of animosity is often characterized by extreme physical violence. In the case of People v. Allen, it was an 8-month period of extended violence between the defendant and the victim. And upon every interaction that they had, the victim fled to her mother's house and they contacted the police. In the case of Huntington Life Sciences, it was firebombing, sledgehammer attacks, and physical assaults. Your Honor, in the case at bar, we see nothing of that nature. Instead, we see two people who have been friends for 8 whole years, and even after Ms. Smith first dropped Mr. Klein as a friend 2 months ago, nothing in their interactions is characterized by any sort of physical violence. And because this message was sent online after a series of embarrassing antics among friends, it's unreasonable to believe that Mr. Klein's vague statements of "I'm coming for you" meant that he was going to escalate this online bickering to extreme physical violence. Now, the defense also believes that the prosecution will try to convince you that there was conduct suggesting an immediate prospect of an execution of a threat to kill, that was swatting. But Your Honor, we see what immediate conduct is in the case of People v. Martinez. In that case, it was arson. Even if we do assume that Mr. Klein was the one who sent in the false report to the police, which resulted in the SWAT team being sent to his house, that's not immediate conduct suggesting that Mr. Klein meant he was going to kill Ms. Smith, because swatting, Your Honor, lacks the inherent violence of something like arson. Because the two factors that make a statement a true threat don't exist in our case, the defense respectfully moves to dismiss count 2. Thank you.
Response from the prosecution.
Yes, Your Honor. Your Honor, before I proceed, I would like to state that I'm feeling a little under the weather today, so my throat may be hoarse. And I apologize and excuse myself for coughing during the motion if that happens. May I proceed?
Proceed.
Your Honor, may it please the court, the First Amendment does not protect speech that threatens to physically harm others. On August 14, 2018, the defendant had posted a comment on Ms. Smith's NowPick account that stated, "You deserve to die. I'm going to get you for this. You just wait. I hate you. When you're dead, no one will even miss you, you monstrous slime of a person. You think you can stick me with a $34,000 lawsuit and just get away with it? Watch your back, Sawyer. I'm coming for you." Your Honor, this statement is not constitutionally protected speech under the First Amendment and is a true threat. This is for 2 reasons. 1, the intent to inflict harm that was evident in the threat, the form of communication, and the defendant's intention that the comment be understood as a threat. And second, the surrounding circumstances and the wording of the threat that caused the victim to be in sustained, reasonable fear for her safety. The defendant had exhibited an intent to inflict harm by deliberately posting the message via social media. In the case of DC v. RR 2010, it was held that the threat in that case wasn't just a few heated words shouted out during a brawl. It was a series of grammatically correct sentences that took time and thought to compose. Additionally, the defendant had to decide whether or not to send it, thus showing deliberation in both the message and the transmission. Similarly, in our case, the defendant had shown an unequivocal and unconditional intent to inflict harm when he deliberately targeted the victim, Sawyer Smith. Additionally, the defendant had written a comment that was several sentences long, took a lot of time to write, at least several minutes, and was clearly targeting Ms. Smith, showing that there was both deliberation in the message and deliberation in the transmission because the defendant chose to send it. Additionally, Your Honor, it is not, although there is no specific language in the threat, the case of In Re George T. held that it is not necessary for a threat to have specific language if there are surrounding circumstances like a history of animosity, threatening or incriminating gestures, and an immediate prospect of execution. In the case of Huntington Life Sciences v. Stop Huntington Animal Cruelty USA Incorporation 2005, there was a clear history of animosity between the employees and the activists. Similarly, in our case, there was a long history of animosity where the defendant repeatedly tried to embarrass, humiliate, and verbally abuse Ms. Smith through social media, her largest source of income. Thus, this history of animosity does predict significant violence in the future, given that the defendant did have a motive. Additionally, Your Honor, it is not necessary to show that a victim is in sustained fear in order to be in sustained fear. Your Honor, the victim in this case had stated that she was freaked out about the message, but tried to play it chill because She wanted to appear tough in front of her followers. In fact, the case of People v. Chandler stated that it's not necessary to show that you are in sustained fear, because most people who are in fear desire not to show it. And lastly, Your Honor, there is immediacy in this threat because the defendant never specified when he was coming to get the victim, but simply stated, "I'm coming for you, you just wait." Your Honor, the prosecution asked the court to respectfully deny the defense's motion because the government has a responsibility to protect its citizens from violence or the fear of violence. Please deny the defense's motion to set aside count 2 criminal threat as a matter of law and allow it to proceed to trial where it can be prosecuted and proven beyond a reasonable doubt that it was the true threat. Thank you, Your Honor.
Rebuttal, Your Honor.
Proceed.
The defense has 2 points of rebuttal to Ms. Narayan's arguments. One surrounding the history of animosity, and the second surrounding Ms. Narayan's argument that Ms. Smith was in a state of sustained fear. First, Your Honor, to address that history of animosity. It's true that Mr. Klein did embarrass Ms. Smith online and did catfish her. However, the 2 of them have been friends for 8 whole years. And even after Ms. Smith first dropped Mr. Klein as a friend, nothing in those 2 months is characterized by any sort of physical violence. Here in context of their relationship, the only reasonable and the only logical conclusion is that perhaps Mr. Klein was going to continue to publicly humiliate Ms. Smith online, potentially try to catfish her.
If one is going to try to look at the facts and circumstances, obviously the words that are used and the surrounding circumstance, there's the job loss, but also there's the other disputed issue as to who called the SWAT team. Can I decide this motion without hearing the evidence and deciding whether or not the party who is accused of swatting is the defendant? In other words, if that were found to be true, is that among the facts and circumstances that would bear on evaluating this alleged threat?
Your Honor, the defense has filed a 995 motion to dismiss count 2. And because we are filing this motion and arguing this motion as a matter of law and not a matter of fact, we will temporarily assume that Mr. Klein did in fact send the false report to the police that resulted in the SWAT team being sent to his house.
So for purposes of this motion, you're not conceding as a fact, but for purposes of this motion, I should assume that among the facts and circumstances is the swatting.
In the preliminary hearing, Your Honor, that fact was brought out. And the defense, although we do not believe or concede that, we will temporarily assume it to be true. However, even when we do assume it to be true, we see what conduct suggesting immediate prospect is in the case of People v. Martinez. In that case, Your Honor, the defendants set off fires within the victim's building. Setting off fires is an inherently dangerous and extremely violent act. Swatting, Your Honor, is not. It lacks that inherent violence of arson. Moreover, when we look at it through the perspective of Mr. Klein and consider their relationship that isn't characterized by any sort of violence, any sort of physical violence, we see that swatting was a thoughtless, potentially reckless act that, though mean-spirited, lacked any sort of intention to cause great bodily injury or physical harm to Ms. Smith.
What's to be made of matching the swatting incident with the earlier action that cost him a job?
Ms. Smith telling on Mr. Klein?
Right.
Your Honor, it wasn't until Ms. Smith posted the "feeling when you win" hashtag "too bad so sad" that Mr. Klein even responded with this message, this mean message to Ms. Smith. Any sort of history that Mr. Smith and Mr. Klein had isn't characterized by any sort of physical violence, which makes it unreasonable to believe that vague statements like "I'm coming for you" meant that Mr. Klein was going to take this bickering to extreme physical violence. Because there is no history of violent interactions, it's unreasonable to draw that conclusion. And there are no other surrounding circumstances which could raise Mr. Klein's vague statements of "I'm coming for you" and "I'm going to get you" to a true threat, which makes it so that there is no clear expression of an intent to commit an act of unlawful violence. That first prong isn't satisfied, and neither is the second. Mr. Klein's statement would not have then put a reasonable person in a state of sustained fear. Moreover, Your Honor, Ms. Smith was not in a state of sustained fear. Immediately upon receiving the message, Ms. Smith responded, LOL, as if you're done now, bye. She never contacted the police like the victim did in People v. Allen, and the case of In re Ricky T specifically states that if a person does not contact the police, their fear is no more than fleeting. Because these two factors don't exist, the defense moves to dismiss count 2. Thank you.
Yes, Your Honor. Your Honor, Ms. Ramanathan had first stated that there can't be a history of animosity between the defendant and Ms. Smith because they had been friends for over 8 years. And there was no extreme physical violence in their history as shown in the case of Huntington. However, it is not necessary for a history of animosity to have physical violence. For example, in the case of People v. Chandler 2014, the defendant had always shouted profanity when he saw the first victim, whenever he saw the first victim. And that was considered to be a true hateful history of animosity, the same type that is present in this case. Additionally, the history of animosity and the 8-year friendship both give the defendant a lot of information about the victim. The defendant knows where Ms. Smith lives, where Ms. Smith sleeps, where Ms. Smith works. Thus, the defendant clearly has the motive and the means to go after Ms. Smith. Additionally,
what should I make of the fact that the police were not called and the victim did not take refuge in a friend's house or somehow try to go to a different location to protect him or herself? You don't have to call in the police. You don't have going to a parent's house or a friend's house. What should I make of the conduct of the victim?
Your Honor, different people have different reactions to frightening situations. For example, let's look at the case of People v. Martinez in 1997. The defendant in that case had threatened a supervisor with vague threats. I'm coming for you. I'm going to get you. However, the supervisor hadn't called the police. Instead, he had spent the rest of the night in fear of what the defendant might do. We have no way of knowing what Ms. Smith was thinking in the time that she had to process the defendant's comment. However, we must allow for the fact that Ms. Smith didn't even have the time to properly process and go over the defendant's comments because she was swatted just mere hours later that night. And that was when she made her conclusion that it must have been Mr. Klein who had called the SWAT team and who had indirectly broken her femur. And that actually takes us to Ms. Ramanathan's other point, which is that we can assume, because of the 995 motion, that there is immediacy. However, Your Honor, the immediacy can only be determined as a surrounding circumstance if we let this motion go to trial. And if we let the prosecution prove beyond a reasonable doubt that it was Mr. Klein who had committed the SWAT call, and it was Mr. Klein who had written a true and criminal threat to Ms. Smith. Your Honor, the state has a vested interest in protecting its citizens from violent situations or fear of violent situations. Today, Ms. Smith has been a victim of that fear, and thus the prosecution implores the court to deny the defense's motion. Thank you, Your Honor.
Very well, I understand that under the rules of the competition, I should allow each side 30 seconds to consult their coaches to see if they want to raise any objection.
None from the defense, Your Honor.
None from the prosecution.
Very well. This is the 995 motion. I believe the issue is whether there is sufficient cause to hold the defendant for trial. And I think a number of these are fact-intensive issues that will turn on trial testimony. And I do not believe I can grant, or I choose not to grant the 995 motion, but we'll certainly consider whether the prosecution has met its burden of proof, which is different at trial than on 995 motion. So, we need to take a break so that the teams can reposition themselves.
Yes, Your Honor.
Thank you.
Rain, the defense has some preliminary matters we'd like to attend to.
The people as well.
guys ready to proceed?
Yes, Your Honor.
All right. What is it you'd like to raise?
We'd like to inform the court that all copies of exhibits have been shown to opposing counsel ahead of time. And we ask that exhibits A and B be marked for identification purposes at this time.
A and B may be so marked.
We would also like permission for both sides to make use of the space to the left of counsel table for opening statements and closing arguments.
May.
We would also like to inquire as to Your Honor's preferences when it comes to approaching witnesses during direct and cross-examinations.
You may approach if you request and obtain permission.
Yes, Your Honor. We would also like to ask if Your Honor has the most updated case materials with the errata dated December 18th, 2018.
I hope I.
If Your Honor would like a copy, we can provide one. With that, the defense is ready.
Do you have anything you'd like to raise?
Just one thing, Your Honor. We'd like to mark exhibits C through E for identification purposes only as well at this time, added to exhibits A and B.
So A, B, C, and D are all marked for identification.
Thank you, Your Honor.
And before we start with opening statements, do both sides waive formal reading of the charge?
Yes, Your Honor.
Yes, Your Honor.
Then we may go to opening statements.
Yes, Your Honor.
May it please the court, Reagan Klein sent a message that Sawyer Smith deserved to die. It started online with a case of harassment and cyberbullying, which quickly moved into a threat left on Miss Smith's NAPWIC account. But when even this wasn't enough, Mr. Klein left a false report to the police, and Miss Smith fell down the stairs and broke her femur. Only then was Mr. Klein's message heard, loud and clear, that Miss Sawyer Smith deserved to die. Your Honor, tonight Mr. Klein is facing two charges. First, he is charged with leaving a false text tip report to the police forces that ended in Miss Smith's broken femur. And second, he is charged with leaving a true and criminal threat on Miss Smith's NAPWIC account. In order to prove both of these charges, we must look at the days, months, hours, and minutes before Miss Smith was swatted. Months before the swatting incident, also known as falsely reporting a text or a emergency to police forces, Mr. Klein and Miss Smith had been the best of friends. But this only went until Miss Smith became a social media starlet. In a fit of jealous rage, Mr. Klein and two friends, Cameron Holmes and Marlo Patterson, decided that they would catfish Miss Smith online in an attempt to embarrass and defame her. Your Honor, only days before Miss Smith was swatted, Miss Smith had gotten Mr. Klein fired from his job, and Mr. Klein, in retaliation, left a threat on Miss Smith's NAPWIC account, saying that she deserved to die, that he was coming for her, that she should watch her back. Your Honor, this sent a clear message that Miss Smith was not safe. And finally, Your Honor, only minutes before Miss Smith was swatted, Mr. Klein was seen putting down the phone that sent the false emergency text-to-tip to police forces. Your Honor, the prosecution has the burden of proof tonight, and we will meet this burden. 4 witnesses will testify to the guilt of Mr. Klein. First, you will hear from Cameron Holmes. She will tell you about the intense anger Mr. Klein harbored towards Miss Smith, and she will tell you that she saw Mr. Klein putting down her flip phone just after the text was sent. Second, Your Honor, you will hear from Miss Sawyer Smith, who will tell you about the months of harassment she endured at the hands of Mr. Klein and the intense fear she sustained after he left his threat on her page. Third, you will hear from Officer Keegan Lopez, the arresting officer the night of the incident, who arrested Mr. Klein for placing the false text-to-tip and for sending the threat. And finally, Your Honor, you will hear from Dr. Dakota Chung, a linguistic analysis expert who will testify that it was most likely Mr. Klein who sent the false text-to-tip message. Your Honor, Mr. Klein sent a message that Sawyer Smith deserved to die. His cause was simple, and his motive was clear. At the end of this trial, we will ask that you please return a verdict of guilty on both counts. Thank you.
Defense?
Yes, Your Honor. May I proceed? The prosecution only ever had 2 suspects. They picked the wrong one. You will hear that this is a case that was narrowed down far too quickly. That this is a case with 2 completely different possibilities as to who sent that false text-to-tip report. That this is a case where the prosecution ignored one of these possibilities and picked the wrong one. Your Honor, you will hear that on August 14th, 2018, Sawyer Smith got Reagan Klein fired from his job. So Reagan, frustrated and betrayed, and after seeing a taunting picture Sawyer had posted on her social media account, left a hurtful comment. Now Reagan will tell you himself that yes, he did make this comment. That yes, he was angry. But he will also tell you that he never intended to act on a single word of that statement. The evidence will show that even Sawyer Smith didn't take Reagan seriously, responding with LOL as if you're done now, bye. Your Honor, prosecution just told you that it was Reagan Klein who sent the false text-to-tip report. But today you will hear about the second suspect. The evidence will show that it was Cameron Holmes who had the means, the motive, and the opportunity to send that false report. You will hear that the phone that was used to send this report belonged to Cameron Holmes, not Reagan Klein. You will hear that Cameron Holmes was in the room with that phone at the time the false text-to-tip report was sent. You will hear that it was in fact Cameron Holmes' message that was loud and clear. She wanted Reagan out of the picture. And she did exactly that. Your Honor, you will also hear from the prosecution's arresting officer, Officer Keegan Lopez, that at the time of the arrest, she did not think she had enough evidence to arrest anyone for the false text-to-tip report. Additionally, you will hear from Dr. Blake Williams, an expert in linguistics, who will testify that the specific vocabulary usage in that false report points to Cameron Holmes as the author, not Reagan Klein. Your Honor, tonight, the prosecution has the burden of proof to prove their case beyond a reasonable doubt. And they will be unable to overcome this burden with the evidence they will present today. Because this case only ever had 2 suspects. And the prosecution picked the wrong one. Which is why at the end of tonight's trial, my co-counsel, Mr. Balaji, will be asking for a verdict of not guilty. Thank you.
Thank you. Any further before we go to the witnesses? Prosecution ready to call first witness?
Yes, Your Honor. If you will call Cameron Holmes to the witness stand.
Cameron Holmes, please approach the witness stand. Right this way, Miss Holmes. Raise your right hand. Do you solemnly affirm that the testimony you're about to give will faithfully and truthfully conform to the facts and rules of mock trial competition?
I do.
Please be seated. State your name, spelling your last for the record.
Cameron Holmes, Holmes.
May I proceed, Your Honor? Good evening, Ms. Holmes.
Good evening.
Can you tell the court a little bit about yourself?
Yes, my name's Cameron, but my friends call me Cam. And I work at a restaurant called Hennessy's, along with Reagan, Marlowe, and Sawyer.
And what brings you to court today?
I'm ashamed of this, but I took part in catfishing Sawyer. And I was with Reagan and Marlo when the swatting occurred.
Alright, let's take a step back. Why did this catfishing begin?
It began in June when Sawyer became famous on this social media app called NowPic. And Sawyer dropped Reagan as a friend. And that really angered Reagan. So then Reagan decided that we should catfish Sawyer.
Objection, Your Honor. Speculation as to Sawyer dropping Reagan as a friend angering Reagan.
Your Honor, may I be heard?
Yes.
Ms. Holmes worked at Hennessy's with the defendant as well as Ms. Smith, and she was there with Reagan Klein through the catfishing account, so she has reasonable knowledge of when Ms. Smith dropped the defendant as a friend and why he came up with the idea to catfish Ms. Smith.
Very well. Lay a foundation. Don't tell me what it is. Lay one.
Yes, Your Honor.
Yes, Your Honor.
Ms. Smith, when did Ms. Smith drop the defendant as a friend?
Well, it began in June, and this was after Sawyer's rise of social media stardom, and that preceded Sawyer to drop Reagan as a friend.
How did this catfishing work?
Well, we created a fake account called Hayden Carlton, and using stock photos from the internet, we flirted with Sawyer.
Who used this account the most?
Reagan definitely used the account the most.
Ms. Holmes, what's your relationship with Ms. Smith like now?
Well, I know Sawyer, but unlike Reagan, I have no personal beef with her.
Let's talk more about Ms. Smith and the defendant. Were there any incidents involving the two of them?
Yes, actually. I saw that Sawyer report an incident to our boss Sam about an oven Reagan broke and lied about, and that caused Reagan to get fired on August 14th.
Did you see the defendant any other time on August 14th?
Well, later that evening, Reagan, Marlo, and I were all hanging out at Reagan's apartment.
What were you two doing at first in the defendant's apartment?
We were just watching TV at first, and then we got hungry, so Marlo ordered a pizza. And she was on the phone the whole entire time, so she asked me to go and get it.
Your Honor, may I approach the witness with President Pre-Martin's Exhibit E? Thank you. Ms. Holmes, I'm handing you Exhibit E. Do you recognize it?
Yes, this is a layout of Reagan's apartment.
And is that a fair and accurate representation of that apartment?
Yes, it is.
Ms. Holmes, using that exhibit, can you tell us where everybody was at the beginning of that night?
Of course. Marlo was in the corner of the room on the phone, and Reagan was sitting at the dining table. And this was all happening right before I went downstairs to get the pizza.
Did you bring your phone downstairs with you?
No, my phone was sitting on the table charging right next to where Reagan was sitting.
So what time did you go downstairs?
I went downstairs at 9 p.m. and I was waiting there for about 10 minutes.
Are you aware that Mr. Patterson's app shows it was delivered at around 2 p.m.?
Yes, but based on my experiences, drivers frequently mark their food as having been delivered before it actually is.
Objection, Your Honor. Speculation as to drivers marking their times earlier.
Your Honor, may I be heard? Ms. Holmes isn't speculating to the driver's inner thoughts or feelings. She's simply testifying to her own experience with the delivery app. So she doesn't lack any personal knowledge. She has knowledge, and she's testifying to that.
Your Honor, if I may. There's been no foundation laid that Cameron Holmes has had any experience using Yum Yum delivery.
I'll lay the foundation, Your Honor. Ms. Holmes, have you used delivery apps in the past?
Yes, I have. I frequently use them.
And what has been your experience with them?
Well, like how I said, based on my experiences, drivers frequently mark their food as having been delivered.
So going back to our timeline, after you got the pizza and came upstairs, what did you see?
Well, I saw Reagan right here closing my flip phone as soon as I came up.
Did you interact with anyone else on that night?
Yes, Officer Keegan Lopez later showed up that night and informed me that a false tip was sent through my phone at 9:08 p.m.
Did she ask anything else of you?
She asked if she could have my phone as evidence, and of course I immediately agreed, and I told her everything that I knew.
And finally, Ms. Holmes, did you send that false text at 9:08 p.m.?
No, I was just getting a pizza that night.
Thank you, Ms. Holmes. Thank you, Your Honor. No further questions.
Your witness.
Good evening, Ms. Holmes.
Good evening.
Now, I want to talk about a point Mr. Singh made on direct examination, your relationship with Sawyer Smith. Now, you said on direct that you had no personal beef with Sawyer, isn't that right?
Yes, that is correct.
And you even told Officer Lopez that you had no beef with Sawyer, isn't that correct?
Yes, I have no personal beef with Sawyer. Reagan was the only one I knew of that actually had it.
But Miss Holmes, you took part in the catfishing prank against Sawyer, isn't that right?
Yes, I did, and I'm so ashamed of that.
You wanted to knock Sawyer off her high horse, isn't that true?
We all did, me, Reagan, and Marlo.
And you thought Sawyer was becoming obnoxious, isn't that right?
Yes, again, we all did. We just wanted to teach her some humility.
And you wanted to end this in the most humiliating way possible, isn't that right?
Yes, we did, and again, I'm so ashamed of that.
So you set up Sawyer on a fake date.
Yes, we did.
And then Sawyer was left alone for 30 minutes.
Yes, she was.
And then a picture was taken of Sawyer sitting alone at this table, isn't that right?
That is correct, and again, I'm ashamed that I even took part in that.
And then this picture was then posted onto a public social media account, isn't that right?
That is correct, yes.
And under this picture was a caption.
Yes, that is correct.
You added to this caption, #karma, isn't that right?
Objection, Your Honor, hearsay to that caption.
I'm sorry, I didn't hear that.
Hearsay as to that caption.
Your Honor, if I may be heard?
Yes.
This falls under the hearsay exception state of mind. Now, the word #karma implies a vengeful state of mind on the part of Cameron Holmes, and therefore this is admissible hearsay.
Your Honor, may I be heard? This statement doesn't show a state of mind. It's simply an isolated statement. It doesn't reveal anything as to Ms. Holmes' inner thoughts or feelings. It's simply a statement she made on a social media post.
Your Honor, if I may make an offer of proof, my next line of questioning will ask Ms. Holmes why she made this statement. Now, I'm certain that Ms. Holmes will testify that she added #karma because she wanted to drive home that Sawyer deserved what was happening to her, and that Sawyer can only blame herself. Now, this is a state of mind of Cameron Holmes, and therefore this is admissible hearsay.
Overruled.
Yes, Your Honor.
Now again, Ms. Patterson, you added to this caption #karma, isn't it right?
Yes, I did.
And despite having no beef with Sawyer, you add this because you wanted to drive home that Sawyer deserved what was happening to her.
Yes, we all thought what Sawyer was doing was obnoxious, and we wanted to turn it a peg down.
So, Ms. Holmes, despite having no beef with Sawyer, you added this because you wanted to drive home that Sawyer could only blame herself.
Again, we all wanted to teach her some humility, but yes.
Ms. Holmes, on the night of August 14th, as you were going up the stairs, you saw Reagan closing your phone.
Yes, I did.
To clarify, this was a flip phone.
This was a flip phone, yes.
And this flip phone needed to be open to check the time. Isn't that right?
Yes, it did.
Ms. Holmes, you're best friends with Marlo Patterson, isn't that right?
Yes, Marlo's my best friend.
But isn't it true that you thought Reagan's trying to steal your best friend away from you?
Yes, at the time I did think that, but me and Marlo are still friends.
But you felt excluded, didn't you?
At the time, yes, I did.
You were jealous of Reagan, weren't you?
I thought Reagan was stealing my best friend, but again, me and Marlo are still friends.
Is that a yes to my question?
Yes, that is.
Thank you, Ms. Holmes. Your Honor, I have no further questions.
Any further with this witness?
No, correct, Your Honor. This must be excused.
Witness is excused.
Your Honor, will people call Miss Sawyer Smith to the stand?
Sawyer Smith, please approach the witness stand.
Ms. Sawyer Smith.
Raise your right hand. Do solemnly affirm that the testimony you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition.
I do.
Please be seated. State your name, spelling your last for the record.
My name is Sawyer Smith, S-M-I-T-H.
Good evening, Miss Smith.
Good evening.
What do you do for a living?
I'm a full-time student at East Flamingo Community College, but I pick up shifts whenever I can at the local restaurant Tennessee's.
And what are some of the things you like to do for fun?
Lately, running my Now Click
Objection, Your
account.
Honor. Relevance?
Your Honor, maybe?
Yes, Your Honor.
Did you finish your answer, Miss Smith?
Lately, running my Nowpick account has actually been taking up most of my time. It started as a place to document some of the cool things I do, but it's turned into something a lot bigger.
And how has this account's growth affected your personal relationships?
As a social media influencer, I found myself facing a lot of new opportunities, and I ended up cutting out a lot of the old, which included my ex-best friend from high school, Reagan Klein.
Miss Smith, do you recognize Mr. Klein in court today?
Yes, he is sitting by defense counsel wearing a purple tie.
Your Honor, may the record reflect that Miss Smith has correctly identified the defendant in court?
She has.
Thank you, Your Honor. Miss Smith, how did the defendant react to the end of your friendship?
Considering he spent months online harassing me and sending me messages from a fake account, I would say not very well.
Now, Miss Smith, how do you know that Mr. Klein was behind this fake account?
After the account posted about a private incident, I knew that it had to be Reagan. There was no one else to witness it when it happened.
All right, let's take a step back. How did your relationship with this fake account begin?
I got my first message from Hayden, the account, near the beginning of July, and right away we clicked. She was perfect.
And how did things progress with Hayden Carlton?
Things got serious when she asked me on a date. I showed up and she never did. I knew she was a catfish by then, and I was crushed.
Miss Smith, did the harassment stop after Hayden Carlton stood you up?
No. The account continued to post lies about me for a couple more weeks.
And how did you react when you learned that Mr. Klein was behind the catfishing account?
Truthfully, I was just hurt. So hurt that I went to our boss at Hennessy's, Sam, and told him about an oven that Reagan had broken on New Year's Eve.
And did this put an end to the harassment?
No, Reagan clearly wasn't done. He left this psycho comment on my Nowpick account the same day.
Miss Smith, do you remember what that comment said?
There's no way I could forget it. He told me, "You deserve to die. I'm going to get you for this. You just wait. I hate you. When you're dead, no one will even miss you, you monstrous slime of a person. You think you can stick me with a $34,000 lawsuit and just get away with it? Watch your back, Sawyer. I'm coming for you."
Miss Smith, how did this comment make you feel?
I was terrified. There's no other way to describe it.
Do you remember the night of August 14th, 2018?
Yes, that was the night that the police broke into my home.
What happened directly after the police burst into your home?
I remember hearing this noise, and I must have jumped because there was this awful pain, and when I woke up, I was told that I had snapped my femur.
Miss Smith, did the harassment ever stop?
The account is gone, yes, but I don't think I'll ever really be over what happened to me.
Thank you, Miss Smith. No further questions at this time, Your Honor.
The witness.
Yes, Your Honor. Good evening, Miss Smith.
Good evening.
I know this is hard for you, so if you need anything, just let me know.
Thank you.
You stated something on direct examination. I made sure to write it down to make sure I got it right. That the comment Hayden Carlton left on your account on August 14th left you terrified. There's no other way to describe it, right?
Yes, the comment that Reagan Klein left on my account left me terrified.
But you responded to this comment saying that you were laughing out loud, didn't you?
As I live life in the public eye now, that's how I chose to respond in the moment, yes.
You responded to this comment saying as if you're done now, bye, right?
Once again, I chose to save face, yes. It's the type of person that I've always been.
And that night, when the SWAT team broke your door down, your first thought was that someone was coming to rob you, right, Miss Smith?
That is correct, yes.
Your first thought had nothing to do with Reagan Klein, right?
No, it did not. It was only after I woke up in the ambulance that I figured it must have been Reagan who had done it.
Is that a yes to my question? Your first thought had nothing to do with Reagan Klein?
Yes, that is correct.
Earlier that day, You had told Sam Kaloshin that you had just found out that Regan Klein had broken his oven, right?
Yes, I did.
But Miss Smith, you've actually known for 8 months, hadn't you?
I have been protecting Reagan for those 8 months, yes.
Is that a yes to my question?
Yes, it is.
Thank you, Miss Smith. Thank you, Your Honor. I have no further questions.
Anything further of this witness?
Briefly, Your Honor. Miss Smith, why did you choose to reply to the thread on your Napic account the way you did?
Objection, Your Honor. Speculation as to the word threat to the extent that it is a legal conclusion. However, if opposing counsel is simply using this to the extent as a colloquial term, the defense has no objection.
Your Honor.
Yes, Your Honor.
Did you answer the question, Miss Smith?
I have always been the type of person that chooses to save face, and I wanted to be tough in front of my followers, no matter how crushed I was.
Thank you, Miss Smith. No further questions, Your Honor. May this witness be excused?
Witness may be excused.
Thank you.
Your Honor, at this time, the people respectfully request a time check for both prosecution and defense on direct examination and closing argument.
Time check.
Prosecution has 5 minutes and 27 seconds remaining for closing and 6 minutes and 17 seconds remaining for direct. Would defense like a time check as well?
Yes, please.
Defense has 5 minutes and 48 seconds remaining for closing and 5 minutes and 33 seconds remaining for cross.
Thank you.
At this time, the people call Officer Keegan Lopez to the witness stand.
Officer Keegan Lopez, please approach the witness stand. Right this way, officer. Raise your right hand. Do you solemnly affirm that the testimony you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
Please be seated. State your name, spelling your last for the record.
Keegan Lopez, Lopez.
May we proceed? Good evening, Officer Lopez.
Good evening.
How are you involved in this case?
I am the officer that arrested Mr. Klein on August 14th for his comments on social media and the anonymous text message.
Take me through the night of August 14th. How did your night begin?
At around 9:08 p.m., I received an anonymous text message about a hostage situation at Sawyer Smith's house. Worried, the police force and I got there immediately and surrounded the residence.
How did you and the police force respond to the situation once outside?
Even after using a megaphone, we got no response from inside the house. So at around 9:20, we broke down the door and shouted freeze, which is proper safety protocol.
How did Miss Smith react when you shouted freeze?
Unfortunately, Miss Smith jumped back and started tumbling down the stairs, snapping her femur. As a result of the pain, she became unconscious, and I rode with her to the hospital.
Was there even a hostage situation?
No, the situation was a case of swatting.
What is swatting?
Swatting is the act of making a prank call or text to emergency services in an attempt to dispatch a large number of armed police officers to a particular address.
So earlier you mentioned that you rode with Miss Smith to the hospital. Did you learn anything about the ordeal during the ride?
Miss Smith appeared to be in an intense amount of pain after she woke up. However, she kept repeating that Mr. Klein had sent the tip.
Did you pay a visit to Miss...
Objection, Your Honor. Hearsay as to the repetition of Mr. Klein's of the text message.
Your Honor, may I be heard? This falls under the hearsay exception of an excited utterance, as an excited utterance is a statement made that describes or explains an event perceived by the declarant, made during or shortly after a startling event. In this case, the startling event was Miss Smith falling down the stairs and breaking her femur, which led her to fall unconscious. And finally, it's made while the declarant is still under the stress of excitement from the event, and Miss Smith had just woken up from her unconscious state, and then she made that statement.
Your Honor, if I may be heard, it's the defense's contention that Miss Smith was no longer under the stress of this event. It was several minutes after she had fallen down the stairs and learned that it was not Reagan Klein at her doorstep, where she had a conversation with a police officer, one which was very productive. Therefore, we don't believe that Miss Smith was still under the influence of this event at all.
Your Honor.
Yes, Your
Your Honor. Did you pay a visit to Mr. Klein afterwards?
Yes, after the trip to the hospital, I went over to Mr. Klein's apartment, where Cameron Holmes and Marlo Patterson were also present.
So while investigating, did you find any evidence that led you to believe that the tip had been sent from that house?
Yes, while I was talking to Mr. Klein, I noticed a flip phone plugged into the wall behind him, and I asked if I could examine it.
Did you see anything related to the swatting incident on the phone?
Yes, I saw the fake tip sent at 9:08 p.m.
Your Honor, permission to approach the witness with what has been pre-marked as Exhibit A.
You may.
Officer, I'm handing you what is Exhibit A. Do you recognize it?
Yes, this is the tip that was sent to me that informed me of the hostage situation at Sora Smith's house and that she was in danger.
And is this a fair and accurate representation of the tip you saw?
Yes, it is.
Now, after discovering this piece of evidence, what was your next course of action?
I interviewed Mr. Klein, Miss Holmes, and Miss Patterson, and I brought the flip phone in as evidence.
After taking all of their statements, how did you follow up on your investigation?
I approached Dr. Dakota Chung, a forensic linguist, to try and analyze who wrote the swatting tip.
And how did you conclude your investigation?
After Dr. Chung concluded that it was most likely Mr. Klein who wrote the tip, I added a false emergency report to his charges.
Thank you, officer. Thank you, Your Honor. No further questions at this time.
Your witness.
Yes, Your Honor. Have a seat. Good evening, officer.
Good evening, sir.
Now, you were personally part of the SWAT unit that raided Sora Smith's house on the night of the 14th, right?
Yes, after I received the anonymous text message.
And upon entering, the SWAT team shouted, "Freeze," right?
Yes, to ensure that any civilians didn't get hurt.
Of course, at which point, Miss Smith jumped down the stairs, correct?
Yes, she must have slipped on she must have slipped down the stairs, yes.
And upon Miss Smith hitting the ground, you heard a loud crack, didn't you?
Yes, I later learned that it was her femur snapping.
And you testified on direct examination that in the ambulance, Miss Smith appeared to be in agonizing pain. Isn't that true?
Yes, that's correct.
So it was after having just come to from being unconscious, and while in agonizing pain, only then did Miss Smith make the statement implicating Reagan Klein. Isn't that true?
Yes, that's correct, but I usually tend to follow any reasonable lead that I get, no matter how small.
Officer, is that a yes to my question?
Yes, that's yes.
You then went to Reagan Klein's house, right?
Yes.
And here you found a flip phone.
Yes, that's correct.
And this flip phone was the same phone used to send the text message, right?
Yes.
Now, correct me if I'm wrong, officer, but that flip phone did not belong to Reagan Klein, did it?
No, it was Miss Holmes' phone, but that doesn't mean that the defendant couldn't have sent it.
Objection, Your Honor, non-responsive.
The answer is stricken from where it starts. That doesn't mean from there on it's stricken. Next question.
Yes, Your Honor. Now, you then interviewed Cameron Holmes, Marlo Patterson, and Reagan Klein, right?
Yes, that's correct.
And you eventually narrowed it down to Reagan Klein?
Yes.
Officer, isn't it true that on the night of August 14th, when you arrested Reagan Klein for the criminal threat, you didn't believe that you had enough evidence to arrest anybody for the false report? Isn't that true?
Not for the false threat at first. I arrested him for his threat on social media, which he already confessed to writing.
Officer, is that a yes? At the time, you didn't believe you had enough evidence to arrest anybody for the false report, right?
At the time, yes.
Thank you, Officer Lopez. No further questions.
Any further of this witness?
No redirect, Your Honor. At this time, may this witness please be excused. At this time, the people respectfully request for a time check on direct examinations.
The defense as well.
Time check.
Prosecution has 3 minutes and 26 seconds remaining for direct examination, and defense has 3 minutes and 25 seconds remaining for cross-examination.
Thank you very much.
At this time, the people call Dr. Dakota Chung to the witness stand.
Dr. Dakota Chung, please approach the witness stand. Right this way, doctor. Raise your right hand. Do you solemnly affirm that the testimony you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
Yes, I do.
Please be seated. State your name, spelling your last for the record.
Dakota Chung, Cheung.
Good evening, Dr. Chung.
Good evening.
What was your role in this case?
I am the forensic linguist that analyzed the anonymous tip, post made by the Hayden account, and post made on Now Pick and Blab by both Mr. Klein and Ms. Holmes.
And what qualifies you to conduct the linguistic analysis?
After double timing as a single mother and student, I got my PhD in linguistics from Western California University. I have since served as an expert on 40 prior cases and have conducted over 100 studies on author identification.
Doctor, can you talk me through how you began to conduct your linguistic analysis?
Yes, I began by using a stylistic approach, which in my professional opinion is more precise and accurate than Dr. Williams' approach based on vocabulary choice. It's better suited for shorter messages and pairwise distinctiveness.
What is pairwise distinctiveness?
Pairwise distinctiveness is the determination of who wrote a message out of a pair of potential authors by taking their distinctive writing features side by side with the ones in the message in question. This is essentially what we're dealing with in this case.
Doctor, what data did you use to begin your analysis?
I began with 76 social media posts given to me by the police and verified to have been written by Mr. Klein.
Your Honor, permission to approach the witness with what has been pre-marked as Exhibit C.
Very well.
Dr. Chung, I'm handing you Exhibit C. Do you recognize it?
Yes, this is the data tables that I compiled.
And is it a fair and accurate representation of your data table?
Yes, it is.
Doctor, can you talk me through the data you compiled from the defendant?
Yes, I compiled Mr. Klein's distinctive writing features into Table 1 of Exhibit C, which included multiple typographic exclamation marks and use of quotation marks.
Did you follow the same analysis process for Ms. Holmes?
Yes, I was given 92 of her social media posts by the police and compiled her distinct writing features into Table 2, which included misspellings and prosodic emphasizers.
So after looking at both the defendant's writing style and Ms. Holmes' writing style, what did you do next with the data?
I compiled both of their distinctive writing features side by sides with the one in the anonymous tip into Table 3 of Exhibit C.
Did you draw any conclusions from Table 3?
Yes, take multiple exclamations, for example. Mr. Klein uses this 12 times in his social media posts, while Ms. Holmes uses this 2 times in her social media posts. It is present in the anonymous tip, making Mr. Klein 6 times more likely to have used it. I followed this for every feature in my table.
So after following this process for every feature in your table, what did you conclude?
I concluded that 8 of the features matched Mr. Klein's writing style, while 4 matched Ms. Holmes. This means that Mr. Klein was twice as likely to have written the anonymous tip.
So doctor, who in your expert opinion wrote the anonymous tip?
Using my expert analysis and the stylistic approach, in my professional opinion, the numbers tell a distinct tale. Mr. Klein wrote the anonymous tip.
Thank you, Dr. Chung. Thank you, Your Honor. No further questions at this time.
You may inquire.
Yes, Your Honor. Your Honor, may I approach Dr. Chung with what has been previously marked and shown to opposing counsel as Exhibit A?
You may.
Thank you. Here you go.
Thank you.
Good evening, Dr. Chung.
Good evening.
Now, Exhibit A, what I've just handed you, that's the text tip that you analyze, right?
Yes, this is the anonymous tip.
And is that a fair and accurate depiction of that text?
Yes, it is.
On line 1 of that text, replacing the word with the letter W. That's more distinctive of Miss Holmes' writing, right?
That is one of the 4 features that match Miss Holmes, yes.
On line 4 of the text tip, replacing the word please with the letter please. That's more distinctive of Miss Holmes' writing, right?
Again, one of the few that matched Miss Holmes.
And on line 4 of the text tip, replacing the word R with the letter R. That's again more distinctive of Miss Holmes' writing, right?
Again, for that feature, yes.
On line 5 of the tip, replacing the word really with the letters RLLY. Again, that's more distinctive of Miss Holmes' writing, right?
Yes, it's not one of the 8 that match Mr. Klein.
Is that a yes to my question?
That is.
And on line 6, the 2 whole word number homophones replacing the word to with the letter 2, those are more distinctive of Miss Holmes' writing, right?
Again, one of the 4 that match Miss Holmes. Correct.
You stated something on direct examination. I thought it was interesting. That because there were 8 features that led to Mr. Klein and 4 that led to Mr. Holmes, that Mr. Klein was 2 times as likely to have written that text, right?
Yes, because like I say, features tend to be a pattern of habit, and Miss Holmes used less of those features.
However, you made a witness statement, right?
Yes, I did.
And you included everything relevant in that witness statement.
Yes.
However, you never include that Mr. Klein was 2 times as likely to have written that tip in your statement, right?
Because there's 8 that match Mr. Klein and 4 that match Miss Holmes, it's simple math that twice as many match.
Objection, Your Honor, non-responsive. My question asked for a yes or a no question about what was contained in her statement, which she didn't answer.
Your Honor,
Can you answer that yes or no?
I believe I did, Your Honor.
Is it a yes?
Yes, it is.
Dr. Chung, your actual conclusion is that the defendant is more likely than not the author of that tip, right?
It is my professional opinion, yes.
Thank you, Dr. Chung. Thank you, Your Honor. I have no further questions. May I retrieve Exhibit A?
Yes.
Thank you.
Anything further of this witness?
Briefly, Your Honor. Dr. Chung, how did you arrive at the conclusion that the defendant was twice as likely to have written the tip?
Looking at my data table in Table 3, 8 of the features did match Mr. Klein while 4 matched Miss Holmes. This would point to Mr. Klein having twice as many features and being twice as likely to have written the anonymous tip.
Thank you, Dr. Chung. No further questions, Your Honor. May this witness please be excused?
The witness is excluded.
Thank you.
Excused. Any further witnesses for the prosecution?
No further witnesses, Your Honor, but at this time, the people would like to mark exhibits A, C, and E as evidence at this time.
You plead to admit the evidence?
Yes, Your Honor.
And you want to admit
A, C, and E.
A, C, and E.
Your Honor, the defense objects hearsay to Exhibit C, although we have no objection to the other 2 A and E.
All 3 will be admitted.
Yes, Your Honor.
Thank you, Your Honor, and at this time, people rest.
Your Honor, at this time, the defense calls Marlo Patterson to the stand.
Marlo Patterson, please approach the witness stand.
Right this way, Miss Patterson.
Raise your right hand. Do you solemnly affirm that the testimony you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
Please be seated. State your name, spelling your last for the record.
Marlo Patterson, Patterson.
Good evening, Miss Patterson.
Good evening.
How are you involved in tonight's case?
Well, I'm friends with Reagan Klein and Cameron Holmes, and I was at Reagan's apartment on August 14th.
I want to talk about your relationship with Reagan Klein and Cameron Holmes. What was your relationship with Reagan?
Well, Reagan and I both go to the same school, Cal, and there we really bonded over studying for our physics exams together. And we also happen to work at the same restaurant, Hennessy's.
Ms. Patterson, what was your relationship with Cameron Holmes?
Well, I've known Cameron for years now, and we also worked at the same restaurant.
So did Reagan start spending time with you and Cameron Holmes?
Yes, actually, although Cameron seemed a little weird about the whole thing.
Ms. Patterson, what do you mean when you say Cameron seemed a little weird?
Well, there was one day where Cameron had approached me, and she said that she wished it was just me and her again, and that she wanted Reagan out of the picture. I thought it was really weird, since I liked hanging out with Reagan.
Objection, Your Honor, hearsay to that statement.
Your Honor.
Sorry, I didn't hear you.
Hearsay as to that statement that Ms. Patterson just said.
If I may be heard? This statement falls under the hearsay exception state of mind, which includes a statement of motive. Now, it is the defense's theory that Cameron Holmes was jealous of Reagan, and because of this jealousy, sent the false text-to-tip report to get Reagan out of the picture, as Cameron Holmes has said. Now, this falls under the hearsay exception state of mind, as this is a statement of motive on the part of Cameron Holmes. Therefore, this is admissible hearsay.
Your Honor, may I be heard? there have been no surrounding circumstances shown to say that this is in fact a statement made by Ms. Holmes that shows her motive. Simply saying that she wishes it was just the two of us doesn't show any criminal motive in any sense. It's simply a statement of, it's simply an isolated statement that she made, so it doesn't fall under the exception for state of mind in this case.
Your Honor, if I may, this witness also testified to Cameron Holmes saying, "I wish Reagan was out of the picture." And additionally, to opposing counsel's point, "I wish it were just you and me again." This is a statement that falls into the state of mind exception because this is a want. This is a state of mind of yearning for Cameron Holmes' best friend. This is admissible hearsay.
Your Honor, if it may be heard one last time.
Yes.
Again, the statement that Ms. Holmes made does not show any intent to carry it out. It doesn't show that she's going to commit any action to it. It doesn't show her motive in any way. And so this would not fall under the exception for state of mind.
Ooh.
Yes, Your Honor.
Ms. Patterson, did you get a chance to finish your answer?
I did, thanks.
Now, you also mentioned that on the night of August 14th, you were at Reagan's apartment. What, if anything, did you do that night?
Well, Cameron and I were both over at Reagan's apartment that night, and Reagan had actually been fired that day. So I thought it was a good idea if I ordered a pizza for all three of us.
And how did you order this pizza, Ms. Patterson?
Well, I ordered it off of this app called Yum Yum Delivery, and from there I ordered it from Joe's Pizza Shop, which is Reagan's favorite.
Your Honor, permission to approach this witness with Exhibit B?
You may.
Ms. Patterson, can you tell me what I've just handed you?
Yes, it's a screenshot of my Yum Yum Delivery order history.
And is this a fair and accurate depiction of your Yum Yum Delivery order history?
It looks like it.
Your Honor, at this time, the defense moves Exhibit B into evidence.
Admitted.
Ms. Patterson, can you tell me at what time that exhibit says that pizza was delivered that night?
Well, here it says Joe's Pizza Shack, and under it says delivered at 9:02 p.m.
And who went to retrieve this pizza when it was delivered?
I sent Cameron downstairs to go get it since I was on the phone with my sister.
Ms. Patterson, did anything significant happen after this pizza was delivered?
Yes.
Objection, Your Honor, vague and ambiguous.
Ooh.
Did you get a chance to answer, Ms. Patterson?
No, I didn't. Could you please re-ask it?
Did anything significant happen after this pizza was delivered?
Yes, actually. An officer came into Reagan's apartment and questioned both Reagan, Cameron, and I, and also took Cameron's phone.
And throughout that night, did you see Cameron's phone?
Yes, of course. Cameron was on it regularly throughout the night since it was her phone.
Ms. Patterson, what happened after the officer took his phone?
After the officer took Cameron's phone, Reagan got arrested. I was completely shocked by the whole thing.
Thank you, Ms. Patterson. Your Honor, I have no further questions at this time. Permission to retrieve Exhibit B.
May. You may, Mark.
Good evening, Ms. Patterson.
Good evening.
You and the defendant worked together at Tennessee's, correct?
Yeah.
You've worked numerous summers at this restaurant?
Yes, I have.
And this summer you became especially close, isn't that right?
Yeah, with Reagan.
And this happened after Ms. Smith dropped the defendant as a friend, correct?
Yes, I believe so.
And you're testifying for Reagan Klein today.
Yes, Reagan's my friend.
And as part of this friendship, you were part of the catfishing of Sawyer Smith, correct?
Objection, Your Honor. Lack of foundation as to how this witness knows even what catfishing is.
Ooh.
Yes, Your Honor.
I'll re-ask the question. You were part of the catfishing of Sawyer Smith, correct?
Yeah, along with Reagan and Cameron.
But of the three of you, it was the defendant who used this account the most, isn't that right?
I think so, out of all three of us.
Right, let's move to the day of August 14th. This is when Ms. Smith got the defendant fired, correct?
Yeah, it was that day.
And after this event, the defendant made a post on Ms. Smith's social media account, didn't she?
Yeah, Reagan later told us about it when I was at the apartment with him.
And this post was made only hours before the swatting incident, wasn't it?
Well, I wasn't there at the swatting incident, but I believe so, yes.
Let's talk more about that night. You, Ms. Holmes, and the defendant were at the defendant's apartment, right?
Yes, all three of us.
And then you ordered a pizza from a delivery app?
Yeah, from Reagan's favorite restaurant.
Then your sister called you at 8:57 p.m., correct?
Yes, she had some news for me. She told me that she was finally getting married after 8 years of dating her fiance. And that I was going to be the maid of honor. It was truly a miracle.
Objection, Your Honor, non-responsive, as well as relevance.
Answer stricken. What's the question again?
I believe I asked her, your sister called you at 8:57 p.m.
Yes.
Oh, yes, she did call me at 8:57 p.m. It's great news.
Right, so you sent Miss Holmes downstairs to get a pizza at 9 o'clock, correct?
Yes, since I was on that really exciting phone call.
You were on the phone from 8:57 to 9:14 p.m., correct?
Well, I was on the phone for about 20 minutes, so that sounds about right.
And during this phone call, you weren't fully aware of your surroundings, were you?
I was on a phone call, so I could still see and everything, but I was pretty focused on it. As I said, really big phone call.
Right, and you were often out of space during this phone call, were you not?
Well, of course. I was excited about this wedding. I've been waiting 8 years. 8 whole years.
Objection, Your Honor. Again, non-responsive as to my question.
Next question.
Yes, Your Honor. And this post was during this phone call was when the swatting incident occurred, didn't it?
I wasn't there at the swatting incident, but from what Officer Lopez told me, I think that's right.
And you mentioned on direct examination that you saw Cameron Holmes using that phone, correct?
Yeah, regularly throughout the night since it was her phone.
Right, but you don't know what she was doing on that phone, do you?
Well, no, I'm not Cameron.
Right, and you didn't notice when Miss Holmes came back upstairs into the apartment, did you?
I don't believe so.
So you don't know if she came back before or after the text was sent, do you?
Well, no, I'm not Cameron.
Thank you, Ms. Holmes. Thank you, Ms. Patterson. Thank you, Your Honor. No further questions.
Any further of this witness?
No redirect, Your Honor. May this witness be excused?
Witness excused. Step down. Next witness.
Yes, Your Honor. At this time, the defense calls Sam Colostian to the stand.
Sam Colostian, please approach the witness stand. Right this way, sir. Raise your right hand. Do you solemnly affirm that the testimony you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
Please be seated. State your name, spelling your last for the record.
Sam Colostian, Kolostin.
May I proceed? Good evening, Mr. Colostian.
Good evening.
Mr. Colostian, what do you do for a living?
Well, I'm the proud owner of the restaurant Hennessy's. We got the best barbecue in town.
Mr. Colostian, do you have any employees over at Hennessy's?
Yeah, I may not look like it, but I turned 55 last month. So I have Sawyer, Marlon, and Cameron to help me out with my daily tasks.
Mr. Colostian, do you know Reagan Klein?
Yeah, actually, Reagan was one of my employees last year.
You mentioned that Reagan was one of your employees. Why does Reagan no longer work for you?
Well, last year I learned that Reagan had broken my baker's smart oven, and this oven, it was a cornerstone of my restaurant. So when I learned that Reagan had broken it, in my haze of anger, I fired Reagan.
Mr. Colostian, I want to direct your attention to something else. Are you familiar with what swatting is?
I am. I was actually watching a news story about it.
When were you watching the news broadcast on swatting?
About a few days before I fired Reagan.
Mr. Colostian, what exactly was depicted in this news broadcast?
Well, in the broadcast, I saw a person call the SWAT team on his enemy, and as a result of all of this, the SWAT team shot the victim's father. It was heart-wrenching.
Mr. Colostian, who else was in the room with you as that broadcast was playing?
Well, there was Marlo, Sawyer, and Cameron.
Was Reagan Klein in the room with you?
Yes, his expression was actually especially notable.
Mr. Colostian, as per your observations, how did Reagan Klein react to that news broadcast?
Well, Reagan, he looked visibly upset, and I can't blame him.
Mr. Colostian, how long was Reagan Klein your employee before you had to let him go?
6 whole years. I saw him go from high school freshman to college sophomore.
And in those 6 years, would you say you got a chance to get to know Reagan Klein as a person?
Definitely. Reagan is one of the most caring people I've ever met.
In your opinion,
Is Reagan Klein a vindictive person?
No, Reagan.
Objection, Your Honor. Speculation.
Your Honor, if I may be heard. Mr. Closkin has just told us that he was Reagan Klein's boss for 6 years and saw him go from a high school student to a college student. The fact that they have a long history of interacting with one another would make any interpretation that Mr. Closkin has about Reagan Klein's character, falls under the speculation exception of 5 senses.
Your Honor, may it be heard? First off, the 5 senses exception is for opinion testimony, not speculation. Second of all, any employee would seek to put their best foot forward in front of their boss, and hence if any vindictive characteristics did come through, he would seek to hide them from Mr. Colostrin, and therefore it is outside of Mr. Colostrin's personal knowledge.
Your Honor, if I may be heard. This does fall under the exception of the 5 senses, given their long history of interacting with one another. The opposing counsel's argument about Mr. Klein wanting to hide his potentially vindictive nature goes more to weight rather than admissibility.
I stand by my response, Your Honor. Yes, Your Honor.
Mr. Closkin, did you have a chance to finish your answer?
No. Can you re-ask it?
In your opinion, is Reagan Klein a vindictive person?
No. Reagan wouldn't hurt a fly.
In your opinion, is Reagan Klein a violent person?
The Reagan I know? Absolutely not.
Thank you, Mr. Closkin. No further questions.
Your witness.
Yes, Your Honor. Good evening, Mr. Colostrin.
Good evening.
You testified that Reagan Klein has a good character,
Yes, one of the best.
but you were only his boss.
For 6 whole years.
But this was only 6 summers, correct?
Well, 6 summers and vacation time.
But you never had any interaction with him outside of work?
Not that I know of.
Furthermore, Mr. Colostrin, isn't it true that Mr. Klein broke your $34,000 oven
Yeah, unfortunately, he made a mistake.
and you fired him?
Yeah, unfortunately, I did fire him.
You threatened him with a $34,000 lawsuit?
I did. I didn't mean a word of it, but at that moment, in my fury, I did.
This was because you were angry that Mr. Klein had betrayed your trust, wasn't it?
Yes, he made a mistake, and again, in my fury, I did do so.
Furthermore, Mr. Colostrin, despite your high opinion of Reagan Klein's character, you still fired him on August 14th, 2018?
Yes, again, out of my fury, I made a mistake, and I should reconsider that.
Thank you, Mr. Colostrin. No further questions, Your Honor.
Anything further of this witness?
No redirect, Your Honor. May Mr. Closkin be excused?
Step down, sir.
Thank you.
Any further witnesses to be called?
Your Honor, the defense calls Dr. Blake Williams to the stand.
Dr. Blake Williams, please approach the witness stand. Right this way, doctor. Raise your right hand. Do you solemnly affirm that the testimony you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
Please be seated. State your name, spelling your last for the record.
Dr. Blake Williams, Williams.
Your Honor, before the defense proceeds, we respectfully request a time check.
Defense has 8 minutes and 26 seconds remaining for direct. Would prosecution like a time check as well?
Yes.
Prosecution has 6 minutes and 10 seconds remaining for cross.
Thank you. Good evening, Dr. Williams.
Good evening.
What do you do for a living?
I'm a linguistics professor at Cal, specializing in author identification.
And how are you involved in today's case?
For today's case, I was called in to determine the author of a false text-to-tip report.
How did you go about identifying that author?
I began by analyzing the social media posts of the 2 potential authors, Mr. Klein and Miss Holmes. From there, I determined the key stylistic features and the key vocabulary choices of their writing, and then compared it to what appears in that false report to see whose writing matched it more.
Dr. Williams, are you familiar with Dr. Chung's procedures?
I am. Dr. Chung only ever considered one method of analysis. Like myself, she conducted a stylistic analysis focusing on features, but she failed to take that necessary step and consider vocabulary.
Why is vocabulary a necessary step?
There's actually an analogy I like to use, the holistic review in college admissions. Just like an applicant is far more than just their GPA and test scores, our writing consists of far more than just features like commas and exclamation points. You can't leave out vocabulary.
Well, what conclusion did you come to when first looking at stylistic features alone, like Dr. Chung did?
Yes, looking at features alone, I actually do agree with Dr. Chung. The features that are generally distinctive of Mr. Klein's writing do appear more prevalently in the false report.
What about after taking that necessary step of vocabulary analysis?
It was then when it became clear that the evidence instead points to Ms. Holmes being the author, not Mr. Klein.
Let's talk about how you came to that conclusion. Your Honor, may I approach Dr. Williams with what has been previously marked and shown to opposing counsel as Exhibit A?
You may.
Thank you. Dr. Williams, I've just handed you what's already been entered as Exhibit A. What is depicted in this exhibit?
This is a copy of the false text-to-tip report that I analyzed.
And what about Miss Holmes's vocabulary did you find that matched the vocabulary of that text?
In the text-to-tip report, there are references to what someone deserves, and words like really and please, which match Miss Holmes's preferred spelling choices. All three of these words match her vocabulary as well.
Well, did any of the vocabulary of the text match Mr. Klein's writing?
There were some, actually. There were words with the base root part, I-figure expressions, and references to value.
Well, then despite that, how did you conclude Mr. Klein wasn't the likely author?
Well, the vocabulary that matched Mr. Klein's writing doesn't appear in the natural manner that he uses them in his social media posts. Instead, statements like pointed gun at Sawyer's heart seem awkwardly written and then awkwardly dropped in, as if someone were trying to disguise the writing as Mr. Klein's.
So, Dr. Williams, after all of your analysis regarding today's case, what final conclusion did you reach?
My final conclusion is that the evidence points to Miss Holmes being the author, and that she tried to disguise her writing as Mr. Klein's.
Thank you, Dr. Williams. Thank you, Your Honor. I have no further questions. May I retrieve Exhibit A?
You may.
Thank you.
Your witness.
May I proceed? Good evening, Dr. Williams.
Good evening.
Now, it is your conclusion that the tip was written by Ms. Holmes imitating the defendant, correct?
That's correct. The evidence points to her being the author.
However, Ms. Holmes isn't a forensic linguist, is she?
No, she's not.
So she lacked the expertise to conduct a stylistic analysis to identify distinctive vocabulary like you did.
Well, Miss Holmes can look at to see how Mr. Klein writes his social media posts and how he writes in their normal discourse, but she does not have the same expertise that I do, of course.
Okay, so I'd like to talk about the extent to which Ms. Holmes would have to imitate the defendant. You're familiar with Exhibit C, right?
That's correct.
Your Honor, permission to approach the witness with what has been with Exhibit C?
You may.
Now, Dr. Williams, when you analyzed Exhibit C, you agreed that the defendant's writing features were more prominent than those of Ms. Holmes, correct?
The features that are generally distinctive of Mr. Klein's writing do appear more prevalently. When we look at those features, however, we see that Ms. Holmes actually uses them as well.
Okay, so I'd like to direct your attention to the first 6 rows of Exhibit of Table 3 then.
Yes.
These are the features distinctive to the defendant, correct?
Generally distinctive. Ms. Holmes uses them as well.
Okay, so you believe that Ms. Holmes would have to mimic all 5 of the features distinctive to the defendant that were found in the tip?
Well, not necessarily. Ms. Holmes uses those features as well. I could give an example if you like.
Yes.
We could look at use of commas, for example. Mr. Klein uses them 9 times, or ellipses, for example. Mr. Klein uses them 9 times, whereas Cameron uses them 3. It's true that Mr. Klein uses them more frequently in the social media posts that I analyzed. Ms. Holmes uses them as well.
Right, but this was for 3 times in the 92 posts that you analyzed of Ms. Holmes, correct?
That's correct.
While for the defendant, it was 9 times in only 76 social media posts.
That's correct.
Okay, so you base your analysis of Exhibit D off of distinct vocabulary choices, correct?
I did. I looked at vocabulary as well as features.
And you're familiar with the comment that the defendant left on Ms. Smith's NowPick account on the day of the swatting, correct?
That's correct. I'm familiar with it.
So you identified metaphors as a vocabulary feature distinctive to Ms. Holmes, correct?
That's correct.
But the NowPick comment made by the defendant uses a metaphor when it compares Ms. Smith to a monstrous slime of a person, doesn't it?
I suppose that is a metaphor, monstrous slime of a person. It's more of a description. I wouldn't necessarily call that a metaphor. I'm not an English major, of course.
Right, but you are a forensic linguist with a PhD in forensic linguistics.
Yes, I look at words.
Okay, so another feature that you identified to be distinctive to Ms. Holmes was the word deserve, correct?
Yes, that is one that reflects Ms. Holmes' writing.
But the NowPick comment made by the defendant states, "You deserve to die," doesn't it?
That's correct.
And the word deserve was found in the anonymous tip, wasn't it?
Yes, it was.
Thank you, Dr. Williams. No further questions, Your Honor.
Any of this witness?
Yes, Your Honor, briefly. Dr. Williams, although there were some features that pointed to Mr. Klein, why did you still conclude Ms. Holmes was the likely author?
Because they didn't appear in the natural manner he uses them in his social media posts. Instead, they appear as if Ms. Holmes was trying to disguise the writing as Mr. Klein's.
And although there are some uses of Mr. Klein's writing features that he used on the day the text tip was sent, why wouldn't that matter?
It doesn't eliminate the possibility that Ms. Holmes uses those features as well.
Thank you, Dr. Williams. Thank you, Your Honor. I have no further questions. May Dr. Williams be excused.
Can you step down?
And may I retrieve Exhibit C?
You may.
Thank you.
Any further witnesses to be called?
Yes, Your Honor, but first the defense respectfully requests a time check.
For the people as well.
Defense has 4 minutes and 27 seconds remaining for direct, and prosecution has exactly 3 minutes remaining for cross.
Your Honor, at this time the defense calls Reagan Klein to the stand.
Reagan Klein, please approach the witness stand. Raise your right hand. Do you solemnly affirm that the testimony you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
Please be seated. Your Honor, for the safety of you and this courtroom, would you like me to stand in between you and the defendant?
That's all right.
State your name, spelling your last for the record.
Reagan Klein, K-L-E-I-N.
May I proceed?
Proceed.
Good evening, Mr. Klein.
Good evening.
Mr. Klein, you're being accused of a lot of things here today, but all we need is the truth. Did you have anything to do with the SWAT team raiding Sawyer Smith's house on the night of August 14th?
No. Look, Sawyer and I aren't friends anymore, but I wouldn't do that to her. I understand the dangers of that, and honestly, they picked the wrong one.
Well, let's back up a little bit. How exactly do you know Sawyer Smith?
Sawyer and I used to be friends for, 8 years? I mean, we used to hang out all the time. We even worked at Hennessy's restaurant together.
How would you describe the time at Hennessy's?
Well, overall it was fine. Up until I accidentally broke one of their ovens.
How exactly did you break one of the ovens at Hennessy's?
I put some tinfoil in it, and when the oven turned on, well, it was totaled. I was really broken up about it.
Did you inform your boss, Sam Kolosky, that it was you who had broken the oven?
No, I did not.
Did you tell anybody that it was you?
Well, the only person that I told was my then best friend Sawyer. I mean, she was someone I could trust, and she advised me to lay low and not tell her boss, so I did so.
Mr. Klein, you mentioned my then best friend Sawyer. What exactly happened between you two?
One day, Sawyer got a ton of followers on her NowPick account and just dropped me as a friend.
Mr. Klein, how did you feel when your best friend of several years cut you off out of the blue?
Shocked. Betrayed? I mean, I thought our friendship was better than some social media app.
What, if any, actions did you take based on those feelings?
Well, I approached my friends Cameron and Marlowe and had this idea to catfish Sawyer, maybe deflate her ego a little bit.
Would you mind describing for the court what exactly catfishing is?
Sure. Essentially, we created a fake person online and tried to get Sawyer to date this fake person to prank her.
And how did this catfishing eventually end?
Well, eventually Sawyer agreed to meet up with this fake person. So when she showed up to a restaurant and no date was there to meet her, Cameron Marlowe and I took photos of her and embarrassed her online.
Mr. Klein, to the best of your knowledge, did Sawyer Smith ever find out that you were involved in this catfishing?
Yeah, somehow she did.
And how, if at all, did Miss Smith retaliate?
Well, it was only then that she decided to tell her boss that I was the one who broke the oven, after she helped me cover it up.
And Mr. Klein, what happened after Sawyer Smith told your boss about the oven?
Well, I was fired on the spot. And on top of that, I thought I was facing a $34,000 lawsuit.
How did you feel when your former best friend got you fired from your job?
Well, after I saw a post of hers bragging about getting me fired, I was mad. And I left a pretty mean comment under that post.
Mr. Klein, did you mean a word of that comment that you wrote?
No, not at all. I didn't want my words to be taken seriously.
Now, I'd like to direct your attention to later that evening. Did law enforcement pay you a visit?
Yes, I was at my apartment with Cameron and Marlowe, and a police officer came to my door.
And how did the interaction with the officer end?
Well, after questioning Cameron, Marlowe, and I separately for what seemed like a few minutes, she picked me. And I ended up leaving my house in handcuffs. Over what, a prank and a few now-pick likes?
Thank you, Mr. Klein. No further questions.
Good evening, Mr. Klein.
Good evening.
You and Miss Smith used to be best friends, correct?
Yeah, we used to be pretty good friends.
But you started to drift apart after you went to different colleges?
Well, we didn't talk as much. I have some important classes, but we were still friends, of course.
And then Miss Smith decided that she no longer wanted to be friends with you?
Well, it was after she blew up on social media. She dropped me as a friend, yes.
You found this devastating, didn't you, Mr. Klein?
Yeah, I really cared about Sawyer.
In fact, you thought she was a jerk?
Well, I mean, it wasn't that cool of a thing to do, to drop, your best friend for an app.
Is that a yes, Mr. Klein?
Yes,
So in fact, it was your idea to catfish Miss Smith?
it was. And when I approached my friends Cameron and Marlowe about it, they jumped on board immediately.
This catfishing went on for multiple weeks, didn't it, Mr. Klein?
Yes, it did.
And when Miss Smith found out about it, she told your boss about an oven you broke in?
Yeah, after she helped me cover it up for like 8 months.
Mr. Klein, isn't it true that you were fired from your job?
That is true.
You were threatened with a $34,000 lawsuit?
You are correct.
You're a struggling college student, aren't you, Mr. Klein?
Well, sure, college is expensive and Cal is hard.
You're working multiple jobs to keep afloat?
That is true.
So you were angry at Miss Smith, weren't you?
Well, I was more mad after she was bragging about getting me fired. That wasn't a nice thing to do.
And because she was bragging, you posted an aggressive comment on her Nowpick account?
Looking back on it now, it was a pretty mean comment, but I didn't mean it seriously at all.
Is that a yes to my question, Mr. Klein? You posted an aggressive comment?
Yes, it was a mean comment.
You said that Miss Smith deserved to die.
I did say that, however, Miss Smith did not and does not deserve to die. I wasn't being serious.
Nevertheless, Mr. Klein, you called her a monstrous slime of a person?
I did say that.
You said that you were coming for her?
Yes.
And you told her to watch her back, didn't you, Mr. Klein?
Again, yes, I said all these things, but if I meant them, it's a different story.
Is
I did
that
not.
is that a yes to my question, Mr. Klein?
Yes.
Thank you, Mr. Klein. No further questions, Your Honor.
Redirect, Your Honor. Your Honor, brief redirect examination.
Oh, I'm sorry, I thought you said you rested.
No, not quite yet, Your Honor.
Proceed.
Mr. Klein, I'm sorry. Mr. Klein, opposing counsel brought up some comments you made on Sawyer Smith's Nowpick account. Did you have any intention whatsoever that those words be taken seriously?
Objection, Your Honor. This question is asked and answered. It has already been asked and answered on direct examination.
Who rules?
Yes, Your Honor.
Mr. Klein, would you like me to repeat the question?
No. As I said before, I did not mean my words to be taken seriously at all. It wasn't meant like that.
Thank you, Mr. Klein. No further questions. Your Honor, may Mr. Klein resume his seat at the end of the defense table?
No, you said no.
And with this, the defense rests.
All right. Both sides have rested. Take a case. Proceed to closing argument unless either side has something to raise before closing argument.
Nothing for the defense, Your Honor.
And nothing from the people, Your Honor.
All right. Prosecution may give the closing.
Thank you, Your Honor. May I proceed, Your Honor?
You may.
On August 14th, 2018, at 9:08 p.m., Reagan Klein sent a message that Sawyer Smith deserved to die. It was just one in a long line of messages, from the catfishing to the threat to the swatting, aimed at the person who wronged the defendant the most. From the day Sawyer Smith became famous to the day of August 14th, the defendant had only one goal: to make sure his message was heard. The people of the state of California charged the defendant Reagan Klein with making a criminal threat and falsely reporting an emergency. To be the false report of an emergency, 1, the defendant must have falsely and knowingly reported an emergency, and 2, an emergency is any condition that results in someone's safety being jeopardized. Now, there is no doubt that both of these elements have been met, but the central question is, who wrote that text? As you heard extensively tonight, there is only one person who was threatened with a lawsuit because of Ms. Smith, only one person who was fired because of Ms. Smith, and only one person who stated she deserved to die: the defendant, sitting in this courtroom tonight. His cause was simple, his motive clear: to send a final message of revenge to Sawyer Smith, the best friend who had betrayed him. And so, on the night of August 14th, he gathered with Cameron Holmes and Marlo Patterson, just hours after having been fired. But let's walk through the timeline of that night. At 8:57 p.m., Ms. Patterson, having just ordered a pizza, receives a phone call from her sister. She is standing right here in the corner of the living room. 9:00 p.m., Ms. Holmes goes downstairs to pick up the order, but with no delivery in sight, is left waiting here on the front porch for 10 minutes. 9:08 p.m., with nobody paying attention, the defendant, a Cal student with a calculating mind, sees his chance. He sends a text to police from the flip phone located right next to him and falsely reports an emergency at Sawyer Smith's apartment. 9:20 p.m., the police rush into Miss Smith's apartment, and she falls down the stairs, breaks her leg, and is knocked unconscious. When she wakes up, all she can think about is Reagan Klein. Because through all of the chaos, the defendant's message of revenge still rings loud and clear. These facts are corroborated by Dr. Dakota Chung, who concludes that the defendant is 2 times more likely to have written the false tip. Further, as you heard on cross-examination, numerous features found in the false tip match the defendant's comment made just hours prior. Even the defense's own Dr. Williams agrees that a majority of the features match the defendant. She, with no explanation, claims they sound awkwardly dropped in. But to believe that claim, Your Honor, you would have to believe that Cameron Holmes, with no forensic expertise, impersonated Reagan Klein on her own flip phone in a mere matter of minutes. This is unreasonable doubt. Let's then move on to the second count of today's case. To make a criminal threat, the defendant must have 1, threatened to unlawfully kill or injure the recipient; 2, intended to make a clear, immediate, unconditional, and specific threat; and 3, cause the recipient to be in reasonable and sustained fear. Now, there is again no doubt in this case that the defendant made the statement. That's a fact he concedes himself. To understand the defendant's threat, all you need to do is look at the plain language of the message. It reads, "You deserve to die. I'm going to get you for this." As for the second prong, an intentional threat, the defendant clearly stated, "You think you can stick me with a $34,000 lawsuit and just get away with it?" indicating he was angry and seeking revenge. The statement was also immediate, with the defendant warning, "Watch your back, Sawyer, I'm coming for you," instilling fear in Ms. Smith that the defendant could strike at any moment. As for intent, the defendant willingly made the post on social media, where he could have deliberated and rethought his words, but he sent the message anyway. Let's go to the final prong, fear. You heard Ms. Smith emotionally recount her thoughts that night. As you saw and heard, she was terrified when she read that threat, and that fear was reasonable. A struggling college student, the defendant just had his livelihood taken away because of Ms. Smith. The only way he could retaliate just as seriously was by inflicting harm on Sawyer Smith. Your Honor, the defendant simply cannot be trusted. Leading up to the swatting, he lied to his boss about breaking an oven. He lied to Sawyer Smith through the catfishing account. And then on August 14th, he told the biggest lie of them all, swatting Sawyer and causing her to wake up in an ambulance with a broken leg. Your Honor, at 9:08 p.m., the defendant sent his message of revenge. Tonight we ask you to send the message of justice. Please return a verdict of guilty on both counts. Thank you.
Yes, Your Honor. May I proceed? The prosecution only ever had 2 suspects, and they picked the wrong one. The prosecution's case was narrowed down far too quickly and ignores the irrefutable evidence that we heard in trial today that shows that Reagan Klein is not guilty of any crime. Now let's break down the individual charges the prosecution have brought, starting with the first one, the making of a criminal threat. The filing of a false emergency report. Now, in order to prove this, one essential element of the charge is that Reagan Klein is actually the person who sent that text message. Now, recall the testimony of the prosecution's expert, Dr. Chop, who took the stand and told us that it was her opinion that Reagan Klein is the author, but she can't be 100% sure. And recall the testimony of the defense's expert, Dr. Williams, who took the stand and told us that Reagan Klein is not the author of that text message. Now, Your Honor, as you're well aware, according to Calcrum 224, if there are 2 reasonable interpretations of the facts, one pointing to guilt and the other pointing to innocence, you are obligated to adopt the version that points to innocence. And Your Honor, that is exactly what we have here. 2 experts coming to completely opposite conclusions based on the same set of data? That's reasonable doubt, Your Honor. Furthermore, there is a completely viable alternative suspect that the prosecution failed to ever consider. And we heard that person testify on that stand today. That person's name is Cameron Holmes. And evidence has shown that Cameron Holmes had the means, the motive, and the opportunity to commit this crime. Now let's break those down. We'll begin with means. Recall the testimony of Officer Lopez, who took the stand and told us that the cell phone used to send that text message, it did not belong to Reagan Klein. No, it belonged to Cameron Holmes. And evidence throughout the course of this trial has shown us that Cameron Holmes was in the room with that phone the entire evening. Let's move on to motive. Recall the testimony of Marlo Patterson, who told us that Cameron Holmes had become increasingly jealous of the new close bond that Marlo and Reagan were forming. And Cameron herself confirmed that on the stand when she told us that she was jealous of Reagan Klein. She wanted Reagan Klein out of the picture. Your Honor, it's simple. Cameron Holmes thought that Reagan Klein was stealing her best friend away from her. So what does she do? She files a false emergency report. She tries to make it sound like Reagan wrote it, and she uses it to hurt somebody who she knows that Reagan's been having problems with. All to cut Reagan out of the picture exactly like she said she would. And let's move on to opportunity. Recall a Yum Yum delivery, which told us that the notification that the pizza had arrived came in at 9:02 p.m. and the text message to the SWAT team went out at 9:08 p.m. That gives Cameron Holmes a full 6 minutes to walk a flight of stairs, get a box of pizza, and send a text message. Cameron Holmes had more than enough time to commit this crime. Cameron Holmes had the means, the motive, and the opportunity, and yet was completely ignored by the prosecution. Why? Because they already had their suspect. Let's move on to the second charge the prosecution have brought, the making of a criminal threat. Now, once again, one essential element of this charge the prosecution have come nowhere close to proving is that Sawyer Smith was in sustained fear at or around the time she read that comment. Now today, Sawyer Smith took the stand and she told us that she was scared, she was terrified. But Your Honor, Sawyer Smith had the SWAT team called on her. They kicked down her door and her leg was snapped in the process. Sawyer Smith is enraged and just wants some measure of revenge for what happened to her. But let's take a look at the public reaction that she made to her hundreds of thousands of followers right after she read that comment. LOL as if. You're done now. Bye. And let's take a look at what Miss Smith was doing that night. She didn't go to the police. She didn't tell a friend. She made no attempt whatsoever to protect herself. And when she heard the sound of someone breaking down her door, she didn't think it was Reagan Klein. She thought she was getting robbed. In fact, Sawyer Smith told us on the stand today, it only ever occurred to me that it might have been Reagan after I woke up. Your Honor, Sawyer Smith's words and actions lead us to one inevitable conclusion. Sawyer Smith wasn't scared at all. And frankly, she just didn't take Reagan Klein seriously. Your Honor, today it was the prosecution's burden to prove beyond a reasonable doubt that Reagan Klein is guilty of the things accused. And it has become apparent that the evidence the prosecution has presented comes nowhere close to meeting this burden. There are clear elements of both charges the prosecution simply cannot prove to any degree of certainty whatsoever, let alone beyond a reasonable doubt. The prosecution only ever had two suspects. They picked the wrong one, and today they have come nowhere close to proving his guilt.
Stop.
Any further? Rebuttal, Your Honor. May I proceed, Your Honor? There are two possibilities in this case, and the people picked the right one. Let's look at each of these two people's means. Cameron Holmes was downstairs and came back upstairs around 10 minutes, at which time she saw Reagan Klein using the flip phone. On the other hand, Reagan Klein was next to that flip phone the entire time while Marlo Patterson was still on the phone. Let's then look at their motive. Cameron Holmes told you she has no animosity towards Sawyer Smith. On the other hand, Reagan Klein, in that same comment posted just hours prior, stated Sawyer Smith deserves to die and that no one would miss her when she was gone. And when Reagan Klein saw his opportunity, he took full advantage of it by sending a false emergency report to police and causing Sawyer Smith to wake up in an ambulance with a broken leg. Your Honor, there is one interpretation in this case, and it points to guilt. Tonight we ask you to return a verdict of guilty on both counts. Thank you.
Yes, Your Honor. Rebuttal from the defense. There are two possibilities as to who could have sent that text message. Words that Mr. Singh just got up here and told us, and he's entirely correct. There are two people with the means, two people with the motive, and two people with the opportunity. And what does that boil down to? Two reasonable conclusions as to who could have sent that text message. And the law requires you to adopt the version that points to Reagan Klein being innocent. And Cameron Holmes took the stand and told us that she was jealous. I wanted Reagan out of the picture because Reagan stole my best friend. Your Honor, it has become apparent that it was Cameron Holmes' message, not Reagan Klein's, that was heard loud and clear. And with this, the defense respectfully requests that you acquit Reagan Klein of all charges. Thank you.
Thank you. I believe under the rules of the competition, each side has an opportunity to consult their coach and see if they wish to raise any objection.
None from the defense, Your Honor.
None from the people, Your Honor.
Very well. Give an opportunity for the scorers to finish their sheets and maybe Sheriff can call and summon the coordinator of the event.
Yes, Your Honor.
Consider the burden of proof, and based on the burden of proof, find the defendant please on both counts. So, we'll wait for the score to be assembled, but I would like each of our scorers to introduce themselves, say a little bit about what they do in their background, and then provide comments to the participants.
I am Kate Ryan, and I am an attorney in Alameda County and Contra Costa County in the area of real estate litigation and estate planning and family law. And I'm from Oakland, and I went to Skyline. And I just wanted to say how incredibly impressive this was today. I scored the practice session, which obviously was different schools, but I mean, to see that night versus the performance tonight, it's just the amount of work that you put in and the effort is incredible. You should all be very, very proud.
So I'm Commissioner Nikki Clark. I sit in the Family Law Department in Hayward. And I'd first like to say that some of the advocacy I saw tonight surpassed some of the advocacy I had in my department this morning. So congratulations on that. I think I've been involved in this program for about the past 12 years. And the reason I stay involved is because I'm so inspired by not only the work that you do, the dedication that you have, but the quality of what you put into this program is it's wonderful to see. And so I have a lot of individual comments. There were some good objections, there were some missed objections. From my perspective, the best indication of a great trial attorney is the ability to object and to respond to objections. And so that's something when I used to coach this program at Oakland Tech, I used to try to drill into the kids is what objections to anticipate based on the witnesses and how to overcome those objections. I like the idea of the theme by the defense. I thought that was effective. I think themes are great and keep the bench tied into the story you're trying to tell. So congratulations, it was wonderful to watch.
Good evening, my name is Alice Shakina. I'm a mediator, and I mediate divorce cases, landlord-tenant cases, probate cases, and I wanted to tell you guys congratulations. Job well done. I did some of the other scoring for the previous ones, and just to see the caliber of the performances and the arguments, it's like literally another level up. So I want to tell you guys congratulations. My background is also in theater, so I'm also looking at you guys from a theatrical perspective. And so I think that you guys did a great job. I think my commentary for the witnesses would be to flush out your characters a little bit more. I wanted to see more of like, you know, not just that you can say the words and you can say them clearly and loudly, but that you have a personality. And so for several of you, I wanted to see a little bit more of the personality coming through, even though you are acting as a witness, right? Because you still can see the different types of people that are in there. But you guys' objections and the responses, I thought were very good. You were very competent, particularly when the judge was asking you questions or when the other side was objecting. I did not sense any sort of hesitation or insecurity. You guys like really kept that confidence level up, which I think is very, very important. So congratulations, great job. Thank you.
I was really impressed by everyone, and you know, there's some things you all did well. The cross-examinations, I like the way everyone came back and said the answer is yes or the answer is no, whatever. It was there was witness control on cross-examination from both sides. Both the directs and cross were organized. You knew what you wanted from the witness. In all of these mock trial scenarios, there are things you can ask and run down that really don't advance your case. They're sort of inviting alleys that don't lead anywhere. You guys looked right past those alleys. You knew exactly where you're going, and you asked the questions that fit into your theme. It was a very good example of how you identify what you need and you go for it and you emphasize it, and it was very well done. I think it was an excellent job. Thank you.
The prosecution's total score from the 3 scores was 481. The defense's total score from the 3 scores was 509.
Yeah.